Hey, how are you? Welcome back. So as long as I have the camera in my hand here, I'm going to shoot a little bit of background. So that, in case you've ever wondered, is a softbox light. And I have that shining normally onto the left side of my face when I shoot videos, because otherwise I'll have weird shadows and stuff. There's another, actually let me do it this way. There's another softbox light right there, and that actually lights the ceiling, and I have the light bounce down so it kind of illuminates me from above. And I have another one over there, and that lights me from the right side of my face so I don't get weird shadows and I actually look presentable on video and so forth. So let me go ahead and put you guys down, and hopefully, does that work? Okay, perfect. So hopefully we can start the video then. So for those of you who don't know me, my name is Andy, and I am an attorney licensed to practice law in California as well as New York. I am in my office in Modesto, California, so here I normally do all sorts of cases, and this evening I am actually recording a whole bunch of videos and talking to you guys. So in this video I'm going to try my best to explain the various ways in which California determines a will to be valid or not. And when I say will, I'm referring to the, basically the document that somebody prepares when they anticipate they're going to pass away, and they list out, okay, who gets my stuff, and like how much should I give each kid or something. So that's the type of will that I'm talking about. In this video, I'm going to talk about how California law determines whether or not a will like that is valid or not. So this is the second video in my series about the validity of wills, essentially. In the first video, which I will play kind of over my shoulder here, in that first video, I went over the way in which California law requires that a will be signed in the first place. So in that video, I go over non-cupative wills, holographic wills, the witness procedure, if that's something that you're kind of concerned about. Go ahead and watch that video. I'm going to go ahead and link the full video down in the description of this video for you also. So hopefully all of that made sense. So that first video deals with how to sign a will, essentially. And this second video, this one, is going to go over how you actually determine under California law whether or not a will is valid or not. And give you a kind of a background about why this particular kind of concern is actually really important. So the will laws, I guess the laws governing wills and probate and stuff in the United States generally are state dependent. So the thing is, California will have its own set of rules, Oregon will have its own set of rules, Arizona might have its own set of rules. These rules might be somewhat similar in certain respects, but there are a lot of instances in which those rules will be different also. So there's no uniform set of laws about wills, for example. On top of that, people actually move in the US quite a bit. So the thing is, it's entirely possible that somebody might have made a will in Arizona in 2015, for example, and then in 2016, completely unexpectedly, they decide to move to California, and then a year later they die in California, never having updated their will from Arizona, let's say. So in those types of situations, which state's laws do you apply? How do you apply them? Things like that. So that's kind of the background about why this question of how do you determine whether or not a will is valid is important. So in California, the law that is kind of governing this type of question is California Probate Code section 6113, which I'll write over here as well as link down in the description for you. So 6113 is where it's essentially at, I guess, when we're discussing this topic. So 6113 is not a complicated statute, like it's not like super humongous or anything. The first two criteria that they describe in 6113 are actually pretty straightforward. The last criteria is kind of a tongue twister. I rehearsed it and I think I have it down, but we'll see, who knows. Yeah, anyway, we'll do the best we can. So that said, let's go ahead and get started. So the first way under 6113 in which a will be determined to be valid is basically whether or not it was signed in accordance with California law. That first video that I mentioned, that I played over here and linked down below in the description, if you watch that video, I go over two laws, or two statutes. Basically, it's California Probate Code sections 6110 and 6111. And those are the two big statutes, essentially, that go over how to sign a will in California, or how to create a will in California. So if you comply with either of those laws, then you essentially have created a will under the laws of California, and not surprisingly, California will recognize such a will as valid. So that's the first way in which to get a will recognized as valid. basically it's created under California law. The second way to get a will recognized in California as valid is essentially whether or not the will in question was valid under the laws in place at the time the will was signed in the state in which the will was signed. Hopefully that made sense. So I'll give you an example. So earlier I mentioned somebody who was living in Arizona in 2015. They made a will in Arizona in 2015. Then after that they moved to California and then ultimately passed away in California. So if that's the case, then California will basically look at it like this. This person made a will under the laws of Arizona in 2015. What do the laws at that time in Arizona require of a valid will? And let's say there's 10 different things, all 10 right here. And this will in particular complies with all 10 of those things. It therefore does not matter whether or not in 2016 Arizona law was changed to add a couple more things. As long as the will in question complied with Arizona law at the time the will was signed, that's sufficient for California to recognize that will as valid. That's 6113B. So those two are, I would think, the more common situations. The world being as it is, of course, there are kind of the uncommon or kind of atypical sort of situations that inevitably pop up just for you or just when you're least expecting it. So this is where 6113C, for example, I think comes in. So 6113C is a little bit complicated to explain, but I'll give it my best shot. So when you're looking at 6113, you have to examine 3 different possible states. So the thing is, the state where the person who passed away, the decedent, was domiciled, where the person had a place of abode, or where the person was a national. So any state in which any of these 3 things are true at either the time the will was made or the time the decedent passed away. So any state in which any of these 3 are true at either of these 2 times. If the will in question complied with any of these possibly 6 different states, then the will be valid. Hopefully that made sense. The basic idea is, as long as the will in question complied with the law of any of these, as long as the will complied with the laws of any state in which any of these 3 are true at either of these 2 times, then that will be valid also. That's 6113C. So yeah, hopefully that made sense. It's complicated, I think, unnecessarily, but that's the way the law is written. So to sort of recap then, I guess, so under 6113C of the California Probate Code, there's basically 3 ways in which a will be determined to be valid in California. The first is whether or not, basically it was executed in compliance with California law. Number 2 is whether or not the will in question was valid under the laws of the state in which it was executed at the time that the will was executed. So did it comply with the laws of the state in which it was signed at the time it was signed? So number 3 basically is, did the will rather comply with the laws of any state in which these 3 things are true at any of these 2 times? So if any of those are true, then the will be recognized as valid in California. So as you could probably guess, there are a lot of different ways in which a will could be determined to be valid in California. I would imagine in certain instances that's very helpful, and also in a number of other instances that's probably not very helpful. But that is the way life is. So hopefully that made sense. Go ahead and subscribe, share, like, comment, etc. And I will talk to you guys next time. Thanks.